So one thing, you've been told about public interest and public confidence. My lady, I'll refer this court to the submissions I made on the 24th of June. And also, in the case that we have provided, that is the one that was decided by Philomena Mwilo, the Lady Justice Philomena Mwilo, that is Republic versus Musili. At paragraph 12, 13, and 14, my lady. Secondly, you've been told that there is a need that this court must instill public confidence. And we ask ourselves, my lady, what is public confidence? Is public confidence saying that all police officers should not be granted bail? Or is public confidence upholding the provisions of the Constitution that all persons are entitled to bail without discrimination? So I will let the court choose which exactly, when we talk about public confidence, what is public confidence? My lady, you've been referred to the case of Republic versus Frederick Oleliman. And my lady, I must say with a lot of humility and respect for my colleagues, that there's a danger in reading decisions while choosing to omit paragraphs. What we term academically as selective reading. My lady, in the case of Republic versus Frederick Oleliman, the Honorable Judge states gives three substantial grounds that must be demonstrated by the prosecution. Yes?
Which paragraph?
My lady, it was referenced in the case of Republic versus Ayeko, the one that I provided before court, at paragraph 18. The Honorable Lady Justice Rhoda Ruto replicates the reasoning in Frederick Oleliman. And one is whether the accused person will fail to turn up at his trial or to surrender to custody. That is one. Two, that the accused may commit further offenses. And lastly, he or she will obstruct the course of justice. But again, immediately after giving those primary or those three grounds, the court in that same matter goes on to state that the primary consideration in deciding whether or not to grant bail to an accused person is whether the accused is likely to attend trial. In making this consideration, the court must consider...
I'm sorry to interrupt. Is that in the Leliman case or is it in the other case?
It is in the Leliman case.
Paragraph what?
Just read the one that I said.
Paragraph what?
Paragraph 18 of Republic versus Ayeko.
So it is not the Leliman case?
No, just read.
So it is not the
It is not
Leliman
difficult.
case?
It is not difficult.
So it is not the Leliman case?
It is actually is. Not unless
Paragraph
you're saying,
what?
not unless you're saying
Paragraph?
Justice Ruto was actually replicating her own things.
It's not.
No,
It's
my
not
lady,
the one.
my lady, she makes reference and goes on to replicate.
So she simply
Yes.
asked which paragraph,
Paragraph
of the Leliman,
18.
of the Leliman case,
Yes.
or you are saying
Yona,
the judge
Melody,
is
I've
citing.
I've been told I did
I
selective
take so much
reading.
exception.
So that's why I want to know in the Leliman matter, which paragraph is he referring to? Because
My
he's
lady
talking
will
about
also
the Leliman
realize that
matter.
I'm actually responding to the submissions by my senior and my colleague. And they actually cited the case of Frederick Oleliman. Unfortunately, they are not in the habit of supplying they are not in the habit of supplying authorities.
Where is the
to us.
selective reading?
Therefore, I mean, it
Where
is
is
there.
it selective?
Paragraph
what in the Leliman
Let
matter?
me just choose to proceed.
Melody, there's a problem there.
Okay, let's see. we can all read, the court will be able to read, but you have not given the paragraph. So you are citing the decision of Justice Ruto, and you are
Justice
saying
Ruto.
Justice Ruto cited Leliman. Replicated Leliman.
Yes.
We will find it.
Actually, word for word.
The law is like the Bible. We will just find the
Thank you, my lady.
scriptures
So
if we
I do
want
not now understand why there is
If
so much.
it is not there, then the court will not find it, and I will make reference to that.
Thank you. And perhaps next time, my lady, they can also be advised to be sharing authorities.
Okay. Proceed though.
Yes?
Proceed.
Yes.
Actually, the court departed from its modus operandi. I would have adjourned this matter to give you a date to come and make submissions. Probably that explains why they do not have authorities to support. But because I saw all of you here, I decided to proceed. So that is forgivable.
Thank you, my lady.
Because the matter
We
was not
appreciate.
coming up for hearing today, it was coming up for directions on the previous report. But I
Yes, my
decided
lady,
to
we
release
appreciate the
it.
industriousness of this.
Okay, proceed. I missed your third point, whether the appellant or accused will attend trial, whether he will commit other offences, and the next point was?
Yes, and the primary consideration in deciding whether or not to grant bail to an accused person is whether the accused is likely to attend trial.
Yes.
My lady, that sorts that issue of Frederick Oleliman. The third issue was the fact that, again, these are police officers, and I'd like to direct this court to paragraph 12 of Republic versus Musili Durok Kitome.
Republic versus?
Musili Durok Kitome,
Yes.
paragraph 12. And my lady, if you allow me to read or not, it's at your discretion, but I'm trying to save on time. But the gist of that paragraph is that the court is saying that it is not aware of any provision of the law that states that policemen per se is a security risk. Again, it goes on to buttress that there must be equality before the eyes of the law. And on that ground, the prosecutor, or rather the prosecution, was found to have failed in that ground. My lady, next to, going on to my next point, this was the submission by the victim's advocate, where he referred this court to my own authority, Republic versus Obambo, and again selectively chose to read paragraph 14(2)(b) of that decision. And he replicated and said that a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person should be kept in custody for his own protection. That is what he said. But again, my lady, we already established that in fact, in this time and age, Justice Mwilu calls that medieval thinking. You cannot tell an accused person that the only place he's safe is a police cell, or a prisoner remand, my lady. The Constitution binds state organs and state actors by the Articles 29C and 238 to secure the safety of all Kenyans.
Articles?
29C and 238. Therefore, my lady, I would ask this court to shun that medieval thinking, as it was so called at paragraph 13 in the Republic versus Musili Durok case. Finally, in the employment of restrictive measures, where it was argued that he is still a police officer, my lady, I refer this court to the interdiction which was applied to the court, where the suspension was anchored on section 149(9) of legal notice number 90 of the National Police Service Commission Act.
Anchored on section?
Section 14(9) of legal notice 90. And that particular section, my lady, states that, notwithstanding paragraph 8, during an officer's interdiction or suspension, as the case may be, the officer may be required to proceed to his permanent residence and to report to the local police station or post as prescribed in the service standing orders. In fact, verily, my lady, the first accused was directed as a direct order to leave Nairobi and go to Eldoret. And as it has been argued that he's still a serviceman, indeed he is bound by legal notice not legal notice, but the National Police Service Act number 11 of 2014, where he is still subject to discipline and penalties if he disobeys this direct order. And my lady, we therefore submit that having lost his police powers by virtue of that interdiction and being expelled from Nairobi to Eldoret, and as you have been told that this crime actually happened in Central Police Station, which is Nairobi. So therefore we are confident that the first accused person is not going to be anywhere near the scene of crime. That's all, my lady. Thank you.